Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to educate and inform the public, so please subscribe to our channel. When we're talking about the payment of support, which could be child support or spousal support, commonly referred to as alimony, we always have an issue that has to do with sort of predicting the future. You know, the court will say in a judgment, you will pay this amount of child support until such time as the child reaches, let's say the age of 18, until further order of the court. Or you will pay alimony for these amount of years. Why do I say that's about predicting the future? Because it presupposes certain things. It presupposes, amongst other things, that you'll survive in the future, that you will survive employed, that you will make at least the same amount of money that you're making now, that there will be a recipient. We're predicting certain things. If somebody's being awarded alimony, then, the question is, are they going to die tomorrow, and therefore there's nobody to pay the alimony to? What do we do in that scenario? But it's a discussion for another time. What I want to focus on now is what happens in predicting the future if a circumstance comes up and it changes. The most common change of circumstance that occurs in a support environment is someone loses their job. Someone used to get a lot of overtime, they cut it back. Someone's income got reduced from $1,800 a week to $1,000 a week. Well, that's a big difference, especially in what's available to them to spend on family, and that might include child support. So what do you do? In a situation where that occurs, the good news is that when the court will make an order of support, particularly child support, that order is going to stay into effect until further order of the court, and the court may well change that order if there's a substantial change in circumstances. So in other words, if somebody does lose their job, either because of cutbacks or because they go to jail for some reason, and they're not available to do their job, that is a substantial change in circumstances which will result in a reduction or maybe even a suspension temporarily of the child support obligations. Same could be true in an alimony obligation. But here's the key. The court doesn't monitor your life, okay? The court doesn't know, amongst all the people that are paying support, be it child or otherwise, the court doesn't monitor what all those people are doing. Do they have their jobs? Are they still making the same amount of money? Have they gone to jail? Have they got an increase? Have they got a decrease? The court doesn't do that. The court will never know that there's a problem one way or another unless you tell them. So when you lose your job or you sustain a significant decrease in wage, it is your burden to have your lawyer file appropriate motions with the court saying there's been a change in circumstances, I've lost my job, and therefore I need my support eliminated, suspended, reduced, whatever you need. But if you don't do that, the support is going to keep running at the same level, and when you don't pay it, an arrearage will develop at that level. Then, ultimately, when that arrearage gets big enough to catch someone's attention, that's when the bench warrants start flying. And that's when people start getting arrested for non-support. A lot of people call us up, I had it recently, and said, well, the support is wrong because I was in jail for 3 years. And, the government knows I'm in jail. They held me in jail. How can they say I owe money for support? Well, the answer is that these are different branches of a vast bureaucracy, and they're not interested in taking care of your child support problem. When you get thrown in jail for anything, could be related to drugs or alcohol or guns or traffic or support, it could be related to all that. But the burden is on the payor to let the court know by filing the appropriate motions so that the family court will enter an order suspending the support. And that way it won't continue to develop as an arrearage. But if you don't take care of that, like most things legal and most things in life, it's not going to get better by itself. It's probably going to get worse. If you have any questions about that, reach out. We'll be glad to help you out.